justified by subsequent conduct, and I think you answered that it depends on the applicable law. But as to the argument of the contradiction made by respondent, the contradiction between the financial statements and the SPA, is your factual position that there is no contradiction, that it's consistent, or not? To understand well your position, what's the position? I'm not saying who is right or wrong, but what's the position on your side?
I think.
Can you press the button?
Yes, Professor Gaillard, I think, again, I'm telling it to you first as it happened. It's two people that know one another who wanted to enter into a conditional sale agreement, and both had the intention to meet that. So at the earlier stages, they were thinking that this would close very rapidly within the confines of a conditional sale. So I think it is very consistent within the context of a conditional sale. Then it dragged, hence you see the change. Hence you see, okay, well, it's true that I have title, it's conditional, he wants to realize it, but he's not realizing it. Okay, I'm going to continue injecting money, I modify, I write to you, okay, each time you may not close, but please know that if you close, now the deal is different, every 10,000 I pay, I'm going to keep back. Even if you can close 1%, I want to retain for 10,000, then it goes up to 20%, I transfer that up to 50% I can get back. So I think everything is consistent in terms of conduct. I tell you this both legally and factually.
Right. So I'm not cross-examining you, but if I were, I would say so. The answer to my question is yes.
Yes.
Well, the first, that's not one of the questions I had reacting to this. Pure question of information. You remember at the first day, just after the first session, you filed on our request a few, in a kind of booklet, a few exchange of letters between the two parties to the SPA. Was that also filed electronically? In case, the paper.
I'm afraid I didn't get your question. The question is, at the provisional measure stage.
I think we were discussing whether there would be, with tribunal, bifurcation.
Yes.
Remember that?
Yes, of course. Right now you pushed for the dates, you squeezed on the dates. I'll never forget it.
Was that done also electronically?
So maybe I can help.
Yes.
If I remember well, there was some discussion of the SPA even at that first hearing that we had.
Mm-hmm.
We had asked for an authentic version of that contract because we had only found an unsigned version of it, as well as any subsequent amendments to it and perhaps correspondence relating to it. And so there was some production that the claimants provided to us in response to that request, which produced an authentic version of the contract as well as a subsequent amendments and perhaps some side letters between the parties. I don't know if it was filed with the tribunal. It was sent to us electronically, and we then took those files and made them exhibits in the case. So they should be in the record, but I think that's how they came to you.
Just in case, if you both
Yes.
could send it to us once more.
Yes.
Okay.
We'll just
The
forward
same,
to you.
exactly the same.
Yes.
Exactly the same. And maybe it's not necessary, but it's prudent, let's say, for us. Okay. Now, I have three questions. One is for Mr. Anwe, but of course the other party is invited to react. You said that the termination of the permit was before the time the schedule of assets should have taken place, or was requested. Is that time relevant?
For the reasons I explained this morning, it would not change our position. Our position is that EuroGas 1 had rights under the treaty when went into bankruptcy, and if a claim arose thereafter, then it would relate back or be derivative from that interest. And Ms. Jarvis answered your hypothetical yesterday about the house, and I think that analysis applies. So in that case, there's no need for us to establish that the talc interests were reassigned before the schedules were filed. I just simply noted it because if the schedules were filed at that point in time, the ICSID claim itself, which can only be owned by EuroGas once, it's the only U.S. entity in this corporate chain, would have to be disclosed with those schedules of assets and liabilities.
So it's an additional.
Exactly.
And I'd like to know if you have a response to that.
I don't know when the deadline or the date for filing schedules was in the bankruptcy case. My answer really is going to be similar to my closing argument, and that is, if the claim under the treaty related to or was derivative of the interest in GmbH, then the debtor would have been obligated to amend its schedules to include that. If the claim under the treaty was not derivative of or related to the interest in GmbH, it would have had no obligation to do that. And that, I think, is the issue that's before the tribunal in trying to figure out the interplay between the bankruptcy code and the treaty. Is, as Ms. Jarvis explained, the two-step process was that claim under international law, one that would be when you owned by, when did it arise, what was the nature of it, and if there was an investment or a claim existing at that time, then it would be property of the estate. And that's when you take in terms of crystallization and when does the claim arise. Those are issues of international law that I am not an expert at. But if it was a property of the estate, it would have needed to be scheduled. I will agree with that.
But suppose that the right, let's say, claim for damages only arose without any connection with anything before, supposing that. But it arose after the beginning of the bankruptcy, but before the time the schedule of assets should have been made. What's the situation then?
The schedules of assets are required to reflect property of the estate as of the date that the case is commenced. And the date on which the schedules are due is irrelevant to that. Whether they're filed 1 week after the case is commenced or 3 months after the case is commenced, they are to reflect ownership of property as of the date is commenced. So as of May 18th, 2004. If the claim is not derivative of or related to the property of the estate as of May 18th, 2004, the claim is not property of the estate and would not need to be scheduled, no matter when the schedules were due or no matter when the claim arose.
Thank you. Now, unless you want to add something?
No, just to clarify, the order to Mr. Wellball and the two other individuals to file schedules of assets and liabilities was entered on January 28th, 2005. So after the reassignment of the excavation area.
Yes, do you agree with the proposition that what must be answered is the property at the time of the
As I indicated, our primary position is and has always been that the ICSID claim itself arose after the filing, but it is a derivative of and relates to an asset of the debtor, which were the rights under the BIT.
But in terms of bankruptcy law, you agree with the premise?
I confess I'd have to
I mean, you
ask
agree
Ms.
with
Jarvis
position.
if the
Well, I
question.
mean, at this point, it's the position of the respondent. I mean, what's the position of the respondent with respect to what needs to be included in the schedule? Is it correct to say that it's only the property of the estate at the date of the initiation of the bankruptcy?
Sitting here right now today, I have no reason to disagree with Ms. Burton that if this was completely unrelated to any property that was previously owned by the debtor as of the time of the bankruptcy commencing, that in that instance, it may not need to be scheduled.
Right, and then position is.
But of course,
that
it
is
is.
fact, what really
Yes.
happened was connected to fact for, right, I understand.
Okay.
Excuse me. Hello, Mr. Chairman.
Hence why I had said perhaps I should speak to Ms. Jarvis first. She apparently has informed us that is not correct, and she in fact testified otherwise. And perhaps we could point the tribunal to that testimony, if it would be helpful.
Yes, if you find the point, well, that can help us. Okay.
Maybe you can come back to that, after the merits, we'll have maybe a series of questions and we can have this one.
Now, question to Ms. Burton. What is your position about the abandonment or non-abandonment of the GmbH shares? Have they be abandoned or not?
Our position is that they have been abandoned, that the bankruptcy case is a unique one in the sense that although schedules were not filed, the trustee intended to abandon them. He had actual knowledge of the GmbH shares and that his intent was to abandon those. It would have been extraordinarily expensive and time-consuming for him to have pursued any of the claims that arose from the termination of the mining rights. So our position is in accordance with the report submitted by Snell and Wilmer.
Thank you. Assuming the tribunal were to decide otherwise, and that's a question for both parties. If the GmbH shares were not abandoned, wouldn't the consequence be that EuroGas 1 ceased to be an investor from the moment, exactly from which moment, by the way, I'm not sure, I think the beginning of the bankruptcy?
If the I'm not sure I understood your question.
It's not a question of bankruptcy law, I must say.
Right, I know, and that's perhaps some of my hesitancy is that international law is not my expertise. But trying to answer your question, the bankruptcy trustee will step into the shoes, so to speak, of the debtor. Whatever rights the debtor had, the bankruptcy trustee would be able to enforce. I don't know if that answers your question.
I think so, yes. On the other side.
I think the estate becomes the investor.
Okay. Last question, and that's a question of clarification, because I'm not sure I understood entirely what Ms. Witt said, because my mind is slow and you were speaking fast. But what is the position, let's say, of EuroGas 2, as to the incidence of the McAllen transaction and what's the relevance to the our jurisdiction? Because I have had the impression, that maybe that's wrong, hearing Ms. Burton, that you abandoned that argument, but then I'm not certain. So
Well, our position simply is that McAllen's irrelevant. The McAllen transaction was either void based on the case that was presented yesterday, the Whittingham case, or if it was valid, then EuroGas won. If the investment was abandoned and EuroGas 1 had it at the end of the bankruptcy, then EuroGas 1 sold it to McAllen, but then acquired it back, all of the shares in GmbH from McAllen before the treaty claims crystallized.
Supposing they crystallized in 2012, that's right?
That's right, or actually any time after the acquisition of the shares in McAllen.
The acquisition. But
Right.
when was that?
It was by the end of November of 2011, when we had all the exchange of all of the deeds that showed how it was acquired.
Okay, any reaction?
Once again, council said by the end of November 2001, we still don't know when that alleged reacquisition occurred or have any evidence that it did occur. And of course it impacts it because the GmbH shareholding, which in turn owned the Rosman interest allegedly, transferred under this new theory. So it has very significant impacts on the tribunal's jurisdiction.
Well, I would disagree with that there's no evidence, because we submitted the transaction documents that show that the shares were transmitted to GmbH, the GmbH shares were transmitted to AG by the end of November 2011. That's why I picked that date. That's when we can be certain that everything was done. Even though, according to the fact that there are no deeds in England, we don't have the actual deeds. We do know that the transfer was completed before the end of November 11 because we have the transfer documents from EuroGas to EuroGas AG.
There is no evidence in the record showing when McAllen allegedly sold GmbH to EuroGas 2. Or I should say, when McAllen was acquired by EuroGas 2. There's just no evidence in the record of that. Those 5 documents they submitted last week do not show that. They do not show the date on which it occurred or that it occurred.
These documents were filed very late and were not discussed, so we have to look at them, of course, and maybe come back to you on that issue. That's not impossible, I would say. Okay, as far as our questions were to be asked, we have completed that, and now we hear you.
Mr. Chairman, before we move on, I think we have found a passage where Ms. Jarvis apparently answered a question that you had raised earlier, and I was too bold in trying to respond to. We have just a minute.
So the first report?
No, I'm sorry, this is your testimony or cross-examination.
Ah.
So the reference is to day 4 of this week's transcript, page 113 to 114, starting on page 113 at line 7, and going until page 114, line 24. And Ms. Jarvis, in fact, cites case law for the proposition that even where a cause of action accrued after filing of the bankruptcy and did not relate to or was derivative from property that the debtor had at the filing of bankruptcy.
Was or was not?
It was not derivative from that. Even in that case, where the court concluded that the claim was a potential claim, that is, that the debtor had enough information to know about that potential, it should have been scheduled, and to quote Ms. Jarvis, it starts on page 114, line 17, because it was not listed as an asset of the bankruptcy, it was not abandoned and could not be pursued by her. In addition to that, she was judicially estopped, meaning she took the position that this didn't belong to her in bankruptcy. She could not now say that it belonged to her thereafter when she sued. And she said, I'm sorry, I can give the name of the case. This is the Stevens case?
Yes.
If I might point
So,
out.
before you, maybe you want to
I would simply
to
say,
answer that, but just to understand, to make sure I understand
Sure.
what the position is. I'm not, again, saying who's right or wrong.
if you look at Ms. Jarvis's testimony on page 114, starting at line 10, she stated that the district court looked at whether this claim was an asset of the estate, and going down to line 14, the court said this is a potential claim and was a potential claim at the time of the filing of the bankruptcy estate. I don't know that that answers your question about a claim arising later and being related.
Yes, but I would like to understand the respondent's position on this. So, the position, as I understand it, expressed here by Ms. Jarvis, is that what's relevant is indeed the date of the opening of the bankruptcy, but if you have not only a claim but also a potential claim at that time, which is the relevant time, the opening of the bankruptcy, that should be declared as well. So that seems to be the gist of it, right?
I'm hesitant to make another mistake.
But because I distinguish,
But that's what I understand,
distinguish the
yes.
date, the issue of the timing was the relevant date, and the issue of what must be, disclosed in effect at that date.
That's how I understand this.
Right, okay, thank you. So that conforms to your position as claimant, Ms.
Yes,
Bartlett?
yes.
Now, to methods.
Yes, thank you, President Maria. Just for the record, we have forwarded, discussed at the 21st of March 2015 letter from us to counsel for respondent, transmitting the documents responsive to the document production order in electronic form. So, for purposes of the closing statement on the merits, you have my outline in front of you, and I kindly ask you to have handy two binders, named binder 1, which is our opening bundle, binder 1 and binder 3. Yes. Yes, please, with the outline for just ease of reference. Mr. President, the opening and the closing statement, I will focus on what you encouraged us to focus on, namely Slovak law, and I'll try to be as responsive as possible to the arguments raised by respondent on the merits section and address even all the documents they rely on in support of their position on the merits. And if you see that I forgot something or did not sufficiently address one, please interrupt me so I can do that. Before I do so, I wanted to make sure that this desire to address above all what you have identified as being your priority not be construed as some sort of renouncement or weakness of our main decision, which is that Slovak law is good, but as professors, you are more than familiar with, a decision can be in compliance with Slovak law, but nevertheless in violation of international law. We submit that even if we were to follow face value the case of respondent on the merits and how Slovak law is, we would still have a violation of international law. And I would just say to you why, before I move on, to say all this doesn't matter because Slovak law is not much different. Why? Because the 2002 amendment was applied to an ongoing investment. Now, we don't have a stabilization clause, I grant you that, but this is not a tax. This is not something for the future. It impacts an ongoing investment and in a material fashion in relation to a deadline. So basically it's telling you, you came in, we gave you something, now the deadlines have changed. So we believe that this, by itself, reliance on this clause, then to kick us out, is in violation of international law. Alternatively, we say that if you turn to tab 25 of the first bundle, you would see that even if you were to apply the 3-year period, there were events between 2002 and 2004, and let's take a non-controversial event, and that is the decision of the MMO saying to that its own district mining court wrongfully denied an application, or at the very least, didn't wrongfully deny an application, but denied it without identifying the documents it should have identified for claimant to practice its claim. And that did so with relation to a decision of earlier 2003, and once it finally said so, the district mining court got its act together, told us what it wanted, and we managed to comply. So even that event alone caused more than 6 months of delay, which was not at all accounted for when the 3-month period was assessed. And moreover, in any event, the way that that provision was abruptly applied against us without questions of due respect to proportionality, without the warning, without compliance with the principle of cooperation, mitigation, assistance, and in any event without compensation, allows us to be entitled to a favorable award on liability and compensation. But I would focus now on the taking more based on the Slovak law and address respondents' defenses. I have in total 28 points that I want to convey to you. First is that the 2002 amendment, which you find at R62, tab 33, with a translation that is contested by us, uses in the original version, Slovak version, the word that you're now familiar with, which is dobivanie. In this regard, you would see that the term was not defined in 2002 amendment, and putting it in a way as if it were you're still your student or intern, in a way that would enable you to draft an award if you were to side with us. That is the purpose of the order of presentation. The term was not defined in the 2002 amendment, nor cross-referenced to any regulation. If you look at R62 tab 33, you see no definition and no cross-reference to any document. If you look at C63 tab 77, you would see that the term is defined in the dictionary as meaning mining, extraction, or excavation. This is the Slovak English translation. It was translated, moreover, spontaneously by the official translators in this tribunal as mining. You have that at tab 78, day 2, pages 192, 194. That's where my learned colleague tried to interrupt, thinking we were a little bit resting, and said, oh, by the way, there is error in translation. The Wilmaya means extraction. Well, that's not the case. And Dr. Rozluznik confirmed that the use of this term in the industry, it used to interchangeably mean mining or extraction, and it did so both in answers to questions put to him by counsel for respondent and counsel for claimant, and you have that reference at tabs 78 and 79. And so did Mr. Courage, in fact. At tab 80, you have the reference day 4, page 220. The other point I wish to make is to address the only thing that the respondent has in his hands to suggest that it meant excavation for purposes of the 2002 amendment. And that is in the outline at 1.3. That is the 1989 decree on safety and health protection relied on by respondent. It's R165, tab 81. It uses the term dobinvaje in Slovak, nothing more, nothing less, simply here as one of the meanings of the term within the context here of extraction. It does not intend in that document to define the term dobinvaje. That is a fact. It is used as extraction, moreover, within the context, a specific and narrow context of safety regulations, and not in relation to any deadlines and obligations. You find one reference I've searched to this document, and it's only at C27, tab 26, which is the 2004 authorization. And you see that on the first page, this law is not referred to for purposes of definition or within the main text body. It is referred to on the third page when the issue of the authorized mining activity are determined in relation to specific conditions. Tab 26. The third page, the second page starts with the technical conditions. It lists some. Then on the next page, it says the applicant will ascribe this decision into the construction diary according to paragraph 23, paragraph 1 letter of the regulation of the State Mining Office, number, and it cites to this law, safety and health protection during work and safety of the operation. Basically, it's a safety regulation provision that addresses this issue, nothing less, nothing more, and uses one of the few meanings of the term. It is not cross-referenced in the 2002 amendment, which we covered. We say the 2002 amendment doesn't define, doesn't cross-reference, nor in the 2005 revocation letter, nor in any of the decisions of the Supreme Court, be it 2008, 2011. Where now does it make its appearance? It suddenly pops up in March 2012, after Supreme Court Decision 1, 2008, no, Supreme Court Decision 2011, the Supreme Court says, hey guys, what did you do? And the district mining office takes it, and you have to text this at R58, page 22, tab 82, to try to now justify in a lengthy way. That's the time they're writing to us, it's premature, don't come in. They're doing all this. And they're substantiating and desperately trying to find something to support their decision and to overcome what the Supreme Courts have stated. And there, the district mining office refers for the very first time to this decree to justify on safety regulations what it did to us. And then it's passed on to the lawyers that feed it to you and us, hence this rebuttal. That's the first point. It leaves us with the fact that you have this term, it's not defined in 2002 amendment, not in the revocation letter, and that term could mean 3 different things. The second point is that the legislative history of this 2002 amendment is explained to us by Mr. Kukelchik. If you turn to tab 83, his first witness statement at paragraph 9. What does he say? He said prior to this 2002 amendment, the situation was as follows. These investors could come in and they did not do anything. They sat on it, basically, either to block competition or try to speculate, and nothing was done. He adds in that paragraph that the mere request for an application was sufficient to sustain their rights. And he uses the word, no actual activity was required. He moves on in that paragraph to say that even if they didn't even, not only didn't have activity, didn't even apply, even it was not absolute right for the district mining office to kick them out. Why do I say this to you? To show you that our proposal to you, that term within that context meant that you start your activity was already a significant improvement. So it's not a case of a logic case, it's a rational step, significant step forward, the interpretation as we understood it of the term, to meaning mining activity, especially if Mr. Kukelchik said no activity was required, we're saying we understood it that you need to start activity. Third point I would like to make is that respondent did not submit one single document by which as a sovereign state it warned us or explained to us the meaning of the term Daubigny directly or indirectly, but only refers to the conferences that were held in relation to the 2000 amendment without providing a proof that at these conferences or in the public or anywhere, that term was explained to mean extraction that needed to be carried out within the 3-year deadline. Fourth point, what does respondent rely on? It relies on 2 documents in support of its case, R0115, tab 84, and the other one is R0181, tab 85. Let's look at the first one, tab 84. It cites these documents, respondent, to say that we were warned that extraction should start, and we have no reason to complain. Let's take 1 second, assume that that warning did occur at that time. It was even on its face already too late, so that's not a proper warning. But let's look what these documents say. They say, if you turn to tab 54, here it says, Mr. Agagos says that the district mining office said that if we did not carry out works, so it is perfectly consistent with the chronology, with the timing, and our understanding of the term. If you move now to paragraph, to the next tab, that's the only other thing they have in their hands. This is a press release, press document, not a press release, a press article. and it refers to Dr. Rozloknik may have said that the Mining Act would require him, the company, to commence the mining activity. Well, I apologize, but this is very consistent with our case that mining activity has to start and not extraction. And Dr. Roslik was not even questioned on this point. Now, fifth point, respondent did not submit. How many witnesses did respondent submit to try to establish that respondent gave claimants notice that Dobinvanya meant extraction? Well, zero. It produced nobody to try to establish that they told us that that term Dobinvanya meant extraction. Well, if someone did tell us that, why are they relying on press releases that don't say that? Where is Mr. Baffy? He's the, I use the word T-boy because they were using it as a T-boy coming for an inspection. He is at all material times head of that office. He is available, he's not retired. If he had told us that extraction was requested from us or expected, he would have been produced, but respondent chose not to do so. Sixth point, claimants introduced two witnesses, Mr. Agiagos and Dr. Rozloznik, who confirmed in writing that a meeting was held during the fourth quarter in 2004 at the district mining office. You have the references at tab 22 with Mr. Baffy, head of the office, and both confirmed at the hearing that Mr. Baffy did not convey any warning or expectations that extraction should by then start. It's at tab 86, day 2, page 91, and at tab 87, day 3, pages 56 and 57. And you have all the references in the outline that will spare you having to rewrite it. And again, these statements stand unrebutted. 7, Dr. Rozloznik confirmed at the hearing that Mr. Baffy did not, during the site inspection of the works on December 8, 2011, express any discontent or warning that extraction had not started. That is at tab 88, day 3, page 58, where he says, in response to my question, did Mr. Baffy express to you or not that you were immunity or not breaching any regulation? I have not heard anything like that, and he definitely never said anything like that. Again, Mr. Baffy is not here to tell us otherwise. But he cannot. Why? Moving to the 8th point, because Mr. Baffy confirmed at Exhibit C28, tab 38, it's the protocol of December 8, 2004, that we were in compliance with the law. Now, the respondent says, well, it could not mean a blanket approval of anything, but this is a factual question. I'm not using that document to try to force a estoppel agreement, argument, or anything of the sort. I'm telling you the reality and how things would have happened if respondent's theory was correct. Mr. Baffy would say, oh my God, extraction? You're not doing extraction, you have just started mining works? What am I losing my time to? Your thing is going to be annulled in a week or so. Well, he didn't say anything of the sort. Rather, he went and issued a protocol that said that we are working and this is compliant. Point 9. Mr. Kukelchik, produced by respondent, confirmed that he did not even bother at any point in time until this very date to check with Mr. Baffy whether he had warned claimants during any pre-revocation meetings that the term Dobinvanye meant extraction, nor whether Mr. Baffy himself understood the term at the time to mean actual extractions. Now, Mr. Kukelchik is not somebody that comes at the hearing and was not involved to address a high-level point. He was the boss the superior office, and he followed all the procedure afterwards. If you look at his testimony at tab 89, day 3, pages 79 and 80, he says, Mr. Baffy, page 79, at 20, he says, Mr. Baffy was not obliged to report or to signal anything other than the violation of legal procedures. The company, Roseman, is an officially entitled company which was perfectly familiar with the law that they have obligation to excavate. I'm not going into the details on the differences between Dauphin-Vanier and Tasba. Any pre-education is not entitled. Mr. Baffy was not responsible to tell them that he will act in a certain way in the future. He could act only after 3 years had elapsed, and this is what happened. Then the next page, you turn, you would see page 83 and 84. I asked him, assume Mr. Baffy had the same understanding, because previously at page 82, he said, we haven't discussed the minutes with Mr. Baffy. And I asked him, he says, I don't need to discuss, and so on. Then I said, well, why don't you need to discuss? Assume Mr. Baffy has some same understanding as my client as to the term. Then Roseman would not be responsible for this. They had the same understanding as Mr. Baffy. Wouldn't that be relevant? I don't know how your client or Mr. Baffy understood this problem. I mean, this is a damning evidence that even in this dispute, for a person that followed the whole process throughout many years, he has not bothered to talk to anyone, and Mr. Baffy has not been offered here. Perhaps with 2 questions to him, we could have this settled. Yes, this is, he would say maybe this, yes, I understood it this way, but that's our problem, that's not our problem. Belmont or Roseman should have known better. But that's the situation that we have inherited. Now, then if you move to point 10, which we just covered at tab 89, is that Mr. Kokelchik's position is that the government had no duty to explain or warn in advance Roseman that its rights were about to be taken, as the law should be complied and understood by Roseman and DMO how it should apply. You have that at pages 79 and 80. Point 11, Mr. Kokelchik confirmed at the hearing that there is no evaluation on the record of the Slovak administration made prior to the 2005 revocation as to where the project stood and was going, and whether revocation would be proportional. I invite you to look at that, tab 90, it's day 3, pages 106, 107. I put to him again, I'm not asking whether you should have done that, why you didn't do that. I'm asking you to confirm basically that you did not see in the district mining office any report nor any evaluation in terms of proportionality, whether the project stood, the intention of the company Roseman to pursue or not, and what were the alternatives. Could you confirm that there was no such evaluation in the records of the district mining office prior to January 3rd, 2005? That's the question. It's a yes or no, and I suggest it is no. He responds clearly, such an assessment was not part of the appellate file, and the mining office was not obliged to conduct such assessment. Point 12. The fact that the term Dauphin-Vanier was explained only in 2007 to mean extraction further supports claimant's position. And this is a fact recorded in the highest court in Slovakia, Supreme Court decision of 2011, C36, tab 39. Moreover, we now know that Mr. Korich, tab 91, day 4, page 20, that the same 27 law, that's even more material, it's only 2007, there must have been a problem, and not just for us, that someone stepped in and said, we need a new act to explain what the term means. So that alone supports heavily our position. But more, when explaining in 2007 that it means extraction, they extended the period from 3 to 5 years. That's even more damning evidence in support of us. That 2007, oh, extraction, that's what we meant, oh, well, 3 years. That's not enough. That's not enough. Let's put it 5 years. 13, the Supreme Court of Slovakia's decision of 2011 sanctioning the 2005 revocation held that the term dominvanie was applied restrictively in these circumstances, and it confirms the illegality of the 2005 revocation under Slovak law. The Supreme Court's decision is also consistent with international law. You have few cases, TechMed versus Mexico and LGE versus Argentina, where it requires for a transparent system so that the investors know beforehand any and all rules and regulations that will govern investments, and all state actions confirming such criteria should relate not only to the guidelines, directives, or requirements issued or the resolutions approved thereunder, but also the goals underlying such regulations. For Argentina, predictable legal framework necessary to fulfill the justified expectations of the foreign investor. Point 15, alternatively, in any event, the taking was, and I'm citing the Supreme Court's decision, this is an additional ground relied on by the Supreme Court of Slovakia to sanction the revocation. It was premature, not consistent with the principle of proportionality, even if dominvanie meant extradition under the 2002 amendment. This is at tab 39, C36, page 25, because it stated you need to look at the underlying objectives to see the position of the claimant, where it stood, where it intended. You need to assess that. The same assessment, by the way, that is admitted on the record to have never been carried out. That's why a lot of these points alone allow us to reach the conclusion we want you to reach, and all of them are interrelated and just aggravate respondent's case. Now, where did the project had kicked off? Respondent in defense tries to post facto create defenses saying, oh, you were not going anywhere. Why? They go back and find Mr. Courage. Who is Mr. Courage? The beneficiary of the taking. Not only is the beneficiary of the taking, he is the one that colluded with the state to kick us out. You have the letters, the correspondences that he has sent, and moreover, the story doesn't make sense. The revocation never identified any financial shortcomings we have or not. There is no such correspondence, and Dr. Rozloznik at tab 94, day 2, pages 90 and 91, said, I never received any complaints or any concerns in relation to our financial capacity. Then Mr. Courage tries to involve us in a construction dispute, an accounting dispute, and I confront him because it doesn't make sense with R169 and CR126. You also have his testimony at day 3, tab 96. He was cash positive. He was cash positive, and it was an advance for works he had not even undertaken. Also, the allegations raised by respondent and Courage via Courage are inconsistent, because he's saying we didn't move the project forward, we were not going anywhere, Robol is a loser, the other is a loser, and then he gets the thing, and what does he do for a month? Tries to negotiate with us to get financing. That also does not make sense. Otherwise, what was our position in 2004? We had truckloads of permits that we had secured during the 2002-2004 period. The respondent tried to engage with our witnesses, but I don't know how they could engage, because the evidence is full of events that record our active involvement and efforts to move successfully the file forward, the project forward. at tab 99, exhibits C259 and subsequent, we have identified a dozen of permits that we secured, which are Annex 4 to the contract with Cedric. There are a dozen more, but those we submitted only by way of example. Then the delays, of course they were delays, but because we were dealing with, imagine the equivalent of Mr. Kukilchik at a low level, when we were applying, they were asking, come back with this. We said it didn't make sense, they come back with this. We said, we didn't make sense, this is the order, go and get it. And this, for example, was sanctioned by the mining office by the decision of May 15, 2003. So at the time, Belmont listed company injecting money during the years 2001, 2004, notwithstanding the conditional sale agreement. You have that with the statement of Mr. Aliagos that refers to exhibits. You have authorization for mining works, C27, tab 26, pre-orders for construction works, C254 to C257, tab 28. That's works that started September 2004. We have a contract signed with Cedric, C259, tab 27. Down payments made and works ongoing and certified by Mr. Baffy to be compliant. Point 16, circumstances surrounding the entire revocation and reassignment. Those circumstances are blatantly corrupt. Corrupt now, I apologize, I mean in the large sense. That means not with standard practice, to be polite, or not meeting the international law norms, up to potentially something else. Again, we do not need to establish corrupt practices, but it's the reality on the ground that only aggravates the situation. Now, the entire revocation and the retender process were not transparent. Mondo and Courage were trying to snatch before the revocation the investment. You have documentary evidence at tab 101, R247. You have also C356, C357, C358 at tab 46, as well as the testimonial evidence of Mr. Courage. Tab 102, day 3, pages 199 to 212, he was explaining to us, yes, prior to the revocation, in November, December, I was meeting these people, I was corresponding with these people. Then he realized somehow that this is odd, so in personal capacity instead of professional capacity, House of Technology, here and there, but it was obvious, he was trying to discredit us and take with Mondo our rights as he ultimately did. And that matches with the inconsistency that on the ground, Mr. Baffy was not raising any problem, but rather certifying and moving our project forward. Then decision to revoke it taken in November, December, according to Mr. Kukilchik at tab 104, his testimony, day 3, page 90, he confirms that the decision was taken in November and December of that year, prior even to the publication, which in turn was prior to the revocation letter that we received. Now, respondent did not produce documents responsive to document production. I will skip that. That is also an aggravating factor. We produced documents and explanation was provided by Mr. Kukilchik that these irregularities are reprehensible, both the contacts, meaning prior to the revocation, and those that were during the tender process. Now, I'll go rapidly because we see that you wish to move forward. 17, rights of Roseman taken and retendered pursuant to the 2002 amendment and its underlying purpose, and now justified on the ground that we lacked intent and resources to carry out the project, whereas no safeguards were put in place by the government to ensure that the new tender will put them in a better situation. In other words, the public purpose whose reason was of pure form as opposed to substance. Point 18, economic agency could not meet the 2002 amendment objectives as it did not have any financial support and was not subject to any scrutiny or valuation by the government. 19, economic agency's victory over industry leader Mondo is extraordinary. Now, I would willing that somebody would overbid someone, but when a contract, a tender doesn't require a bidding amount, and the policy is to move the project forward, it is farcical to suggest that if this was based on meritocracy or for a public purpose, that a company by the name of economy agency would prevail over a world leader. Then you have the complaint of Mondo pointing out serious irregularities, saying that these guys don't even have a credit document, but a letter that does not mean anything from the bank. We asked Mr. Courage about this letter, he doesn't have it, and of course he doesn't have it because that thing is not worth anything. And when the government received that document, what did it do? The complaint of Mondo, it established a commission. All this, the result you have at tab 105, R194. You saw it, remember the document? So, well, I looked at, there was a complaint. There were 6 companies, 5 were disqualified for not providing paperwork. 1 person remained, bravo, economic agency. We're not going to tender, we're not going to see whether public purpose is met, we're not going to address whether the company has backing. Again, it is really laughable. 21, ex parte contacts between government and some bidders during the tender process. Again, we covered that. Criminally reprehensible, tab 103, page 115. Mr. Kohevchik's testimony. Moving on, economic agency did not act as an investor, but immediately tried on the very date. You kick somebody out, you say, okay, we want somebody that is serious, can carry out the project. You give him the contract, despite other world leaders participating. And on the very same day that you're supposed to get the contracts, the guy is negotiating with Rollball and others to pass on the investment, acting as an intermediary. Now, finally, on the merits, VSK missed the 3-year deadline under the 2002 amendment, as well as the 5-year deadline under the 2007 revised amendment by failing to reach extraction still as of this date. That is tab 107, C 306. It's the press article, because otherwise we don't have any information. Only Courage, Mr. Courage said, I believe we reached extraction, I believe. Then he says, when I was a mere employee, I don't know. I only dealt with technical issues. I mean, this in fact alone justifies a holding notably of arbitrariness, discrimination, inconsistency in the application of the mining policy of the government. Now, I won't spend much time on due process nor liability for compensation. Due process violation, to say that everything, you forget about the substance. There was not the slightest good faith. I mean, I'm trying to be mild. Not the slightest good faith in this process. There was not the slightest transparency. Notification after publication, decision well before the publication, pre-cooked procedure, basically. No advance warning, no capacity allowing us to cure. You have asked us for Supreme Court, the Slovak law. What can I offer you more, Mr. President? Then the Slovak Supreme Court decision of 2008, C33, tab 37, page 8 and 9, that says, no, you cannot do that. It's not fair. It violates the right to be heard. You cannot say administrative body functions like this. It's a really good decision. That's why I don't want the position of my client to be portrayed as being critical to the government of Slovakia, to the people of Slovakia. There are very competent, very qualified, very candid organs within the system. And finally, to say due process is not a question of form, simply. It's a question that relates to substance. Why? Because Professor Stem, if they gave us a advance notice, we would have had the benefit of this discussion. We would have sat down around the table, why do you say David Maya means this? It doesn't mean this. Look what we're doing, we're improving your situation. Oh, how you calculate in an event of 3 years? All of this, what we're doing right now, assuming respondent was in good faith and was legitimately construing this provision for the reasons that they indicated against us, would have allowed us in good faith to sit down and possibly settle this and at least put forward our position, which we were not able to do. This is why the treaty, international law provides that irrespective of substantive reasons, the violation of due process during the expropriation gives rise to liability. So again, heads or tails, you want to go international law, you want to go due process, substance, or Slovak law, the result is the same, and claimants on substance would prevail. Thank you for your attention.
Thank you very much. Ms. Polak.
So as a new lead counsel on behalf of the Slovak Republic, I will not waste too much of your time on matters on which you are more knowledgeable, that means public international law. I will just very briefly outline the Slovak Republic defense and show that Slovak Republic's actions do not constitute any violation of either of the both treaties. This is.
Don't speak too fast, both Mr.
Yes.
McGowan will have
I
difficulties.
apologize. This has been my problem since I was a debater in high school, so I try to rectify it. The first reason is that the reassignment was a result of the Slovak Republic's legitimate exercise of sovereign powers, a doctrine that you are all very familiar with. The second reason is that claimants' claims fail under the proper standard under which they should be assessed, that is the standard of the denial of justice. And third, claimants' claims also fail under other standards of protection. First of all, international law recognizes that a state is not liable for non-discriminatory regulatory action adopted in good faith. This is very well known as the police power doctrine, has been applied by a number of tribunals including Slovak, Burlington, and Rex. It has also been recognized that the police power doctrine applies equally to expropriation and non-expropriation claims, as held, for example, in Spiridov versus Romania, or against Slovak. Separate the things for the presentation. We're talking about how the reassignment of Rosmin's excavation area was precisely the type of legitimate bona fide non-discriminatory regulation. It was an implementation of a mandatory provision of the Slovak legislation, the 2002 amendment, which itself, and it was not really contested here, was adopted for a legitimate purpose. The fact is that Rosmin simply did not come close to dobývanie within the 3-year period, and that is why the 2002 amendment had to apply to Rosmin. Second, claimants also complained that the Slovak authorities incorrectly applied the 2002 amendment to Rosmin and subsequently failed to remedy that purported error. And this is a claim on denial of justice. This standard has been specifically developed in international law for precisely these type of claims to address the interplay between the conduct of domestic, administrative, and judicial authorities in international law, which was famously articulated in Yandino versus Egypt. Now, the standard of denial of justice is subject to 2 main requirements, none of which has been met here. First, this is the requirement of finality. which was not met because the final DMO's decision of March 2012, which was confirmed on appeal by the NMO, was not further pursued and challenged by Rosmin. Second, denial of justice is also subject to a very high threshold. This requires a failure of the domestic system as a whole. Mere incorrect application of domestic law does not suffice for a denial of justice. It has been recognized by numerous tribunals that international tribunals do not sit as courts of appeal to domestic authorities, because domestic authorities often apply highly technical matters and decide highly technical matters of national law. Here, the reassignment was substantively correct, all the procedural errors were remedied, and the final product by which the Slovak Republic must be adjudged was simply correct. It should not also be forgotten that years of litigation could have been saved if only Rosmin had pleaded all the alleged flaws of the first reassignment decision already for the first time when it reached out to the Slovak court in 2005. This was explained by Steve Enway on Monday. Independently of the label of denial of justice, the tribunal in EC versus Czech Republic also held that investment claims alleging incorrect decision-making of domestic authorities are subject to the very same requirements. That means systemic failure of the domestic system and the fact that the mere incorrect application of domestic law is not sufficient for a finding of a treaty breach. Claimants' claims also fail under individual standards of investment protection. Notably, the Slovak Republic did not expropriate claimants' investment. Now, the essential requirement for a finding of expropriation is the showing of a taking. Here, the reassignment did not constitute a taking. This was made abundantly clear by the tribunal in Kybrax. That tribunal made clear that cancellation of a permit because the holder of the permit failed to comply with the legal requirements for the permit does not constitute a taking. Here, Rosmin simply did not fulfill the requirement prescribed by the 2002 amendment to maintain its rights to the excavation area, because it did not commence dobývanie within the 3-year period between 2002 and 2005, and therefore the reassignment simply was not a taking. The reassignment was also in the public interest, because it allowed for the efficient use of the talc deposit in Gemerská Poloma, which Rosmin simply was not doing, and it was proportionate. DMO's last decision includes a thorough analysis of proportionality. The DMO explained very well that Rosmin had not used the excavation area effectively between 2002 and 2005, did not make sufficient efforts to access and excavate talc, did not obtain sufficient financing, and all the works on the site were only of superficial nature. The reassignment respected claimants' due process, and it's a claim that they much insist on. It was not the case that the reassignment was carried out without any kind of prior warning. What happened was that the DMO simply made a mistake in the beginning because it did not conduct the reassignment as a formal administrative proceeding with Rosmin as a participant. This, however, was fully justifiable, not only given the novelty of the 2002 amendment, but also the fact that under this mandatory 2002 amendment, Rosmin simply could not regain its excavation area upon reassignment. So that was fully understandable that the DMO did not believe it necessary to consider Rosmin as a formal participant. However, and most importantly, this initial error of the DMO was fully remedied and had no real impact on Rosmin's rights. Therefore, it really can't be said that the reassignment was an expropriation. And the Slovak Republic also did not violate the standard of fair and equitable treatment. At the outset, the Slovak Republic did not breach any of claimants' legitimate expectation that Rosmin would maintain its rights to the excavation area. Rosmin's rights to the excavation area were conditional on fulfillment of certain requirements from the very start when claimants made their investment in 1998 and 2000 respectively. For example, Rosmin could lose its rights to the excavation area if it failed to apply for another necessary permit within the 3-year period and that was the authorization of mining activities. The 2002 amendment then linked the rights to the excavation area to the requirement of actual commencement of dobývanie within 3 years, and claimants never received any assurance from the Slovak Republic that Rosmin would hold its excavation area independently of this legal requirement. That is why claimants' legitimate expectations simply cannot be sustained. Claimants cannot derive any legitimate expectation from the two events that they so fervently rely on. It is the authorization of mining activities issued in 2004, or the inspection of Mr. Buffy at the DMO on the site in December 2004. It has been shown during this week quite clearly that neither of these events related to Rosmin's right to the excavation area. Also, these events occurred much later during the lifetime of claimant's investment and therefore cannot be the source of their legitimate expectations under international law. The Slovak Republic also did not violate the requirement of transparency. My colleagues will now show and later on show that claimants knew very well what the term dobivanie means, as did every person in the mining area in the Slovak Republic from the very start. Claimants' remaining claims are very brief and in fact repeat the same allegations, which are of course incorrect. So in the interest of time, I would not address them at this stage and rather give the floor to the more exciting matter of causation and dobivanie. But I would just point out that my colleague Rostislav will specifically show that the BSK mining simply did start dobivanie within the legal period, and the new claim that claimants have only raised this week, the discrimination claim under the treaty, therefore cannot be sustained either. But before Rostislav will explain dobivanie, I would yield the floor to Dave Alexander with the causation matters. And at the outset, I would just like to point out that, as before, the issue of causation fails on the utter failure of claimants to meet their burden of proof. It is widely recognized in public international law that it's claimants' burden of proof to show that any alleged losses were caused by the breaches of the treaty, so that the breaches of the treaty were the direct and proximate cause of any alleged losses that claimants put forward in this arbitration, and this was blatantly not the case.
Thank you, members of the tribunal. I'm going to discuss briefly some authorities which probably do not require any discussion for this tribunal, and for that reason alone I'm going to move quickly through those slides, but just to sort of set the context. Of course, causation must be established positively, and that is variously phrased as a sufficient causal link between the actual breach of the BIT and the loss sustained. Importantly, the requirement of causation needs to be established by the claimant with respect to each claim, both for expropriation and any non-expropriatory breaches of the treaty. As I said, the tribunal, I believe, well knows the traditional tests. The factual link must not be remote or indirect. Indeed, the test is believed to stem from probably one of the most cited cases in international law, the Torzal factory case, where the Court of Justice said reparation must establish the situation which would in all probability have existed if the illegal act had not occurred, sometimes known as the but-for test. Professor Crawford has discussed it at length, as well as a number of cases. We'll leave you with those slides, but not take more time other than to restate the traditional notion of but-for. So here, but for the reassignment of the excavation area, have claimants actually met their burden of proof to show a plausible path to de-risking of the project, acquiring the funds necessary, which by their own experts' opinion is in the range of just under 30 million euros. Have they shown a plausible path, notwithstanding their control of the projects for almost 7 years? Have they shown a plausible path to secure the necessary capital? And here, their role as the financial supplier is really clear from the very beginning. Indeed, Mr. Robal's testimony and Mr. Pajagosh's testimony say that from the very beginning, Dr. Taser, with whom they met, mentioned the need for a strong financial partner. Same from Mr. Chore. strong financial partner because of the complexity and growing financial demands of the project. So having expressly promised to first Troy and then again contractually to Belmont, which became its partner in the project for a brief time, that such financing would be provided in sufficient amounts to bring the project to commercial production within a specified year. And that year was by 27 March 2002. Having made those express promises, is there any dispute on this record that those promises were breached in serious and persistent ways? We think no. And from the perspective of both Heidecker and Dorfner, whom the tribunal will recall represented world-renowned mining companies in mine development, why did they say financing never came? Because new potential investors lost interest and did not otherwise come to the table because potential investors perceived the mine was too risky. Respectfully, claimants have not seriously sought to respond to that. Despite their years of experience in the earliest stages of the mine development, I mean, think about it for a minute, what Dorfner and Tyson had invested in this project in terms of time, dollars, commitment, diversion from other profitable tasks. Despite all that commitment, when Robal entered, they walked away quickly. They said he was an inappropriate partner. And then what happened next? Despite, as Mr. Hagigos put it, always trying to secure financing, EuroGas actually consistently failed to perform. Hagigos himself said, simply, EuroGas, however, was unable to sell its interest in Rosman and did not provide any financing. Now, that probably overstates it a bit. There were modest amounts of what was referred to as small bills financing, very small amounts. I said in opening that it was the amount of working capital supplied actually was less than 10%. The record now will show you that it was approximately 6.5% of the total working capital needed to bring the mine to production. A pittance in the grand scheme of things. Now, the claimant's case has been that, and I read from 117 of their memorial, which you heard before about, in 2000, once Rosman had concluded its initial drilling program and received the Kloiphofer and ARB studies, any uncertainties regarding the commercial and financial viability of the reserves in the extraction area had been wiped out. The deposit had been de-risked. Now, there were two elements to this supposed de-risking. One, the technical requirements, and two, the finances, which I've noted already. What about the technical requirements? Well, their case on the technical requirements was that with the arrival of the Kloiphofer report, and I now read from 299 of their reply memorial, they say the news there was so good that it, quote, went beyond the expectations of Rosman and its shareholders. With this study, Rosman critically increased the proven reserves. That's magic language in this world. Proven reserves of talc in the extraction area, and at the same time greatly enhanced the level of confidence that could be placed on the reserves. Proven reserves. What was the testimony? I asked Mr. Robal very directly, were there ever proven reserves established? Answer, no. You heard the testimony this morning elicited by Mr. Magnon in cross-examining Mr. Hill. Were there proven reserves? No. That was their case. There were proven reserves resulting from the Kloiphofer report, but the testimony did not sustain it. Instead, Mr. Robal said there were semi-proven reserves which is sort of back to the pendulum of the Kursco standards. But even there, the vast majority of that deposit, according to their own expert, was only an inferred reserve, the lowest on the standard. Now, why does that matter? Well, it matters because when we asked Mr. Robal, would you agree that if, and I'm reading now from page 113 of the transcript, at line 13, would you agree that if semi-proven reserves had ever been discovered, the market might have been interested in that? I ask the question simply because the whole theory of their case is that with the establishment of the technical requirements, financing was ready to roll in. The risk was wiped out. Recall that language? Here's his answer. Semi-proven reserves mean nothing. At line 16, you need proven reserves blocked out 3 sides. If you don't have them, you don't go into production. You don't go into production. I'm sorry, inferred resource is what I should have said. I said reserve, it's inferred resource. So, we submit that on this record, the only real evidence is that there was substantial doubt about the suitability of Mr. Robal as a partner. Look at it, again, get out of the weeds for a minute and think about big picture here. Look at this from an economic lens. If this project had been de-risked, what would we expect of economic actors? De-risk means it's ready for development. The risk is wiped out. It's ready to go to market. Despite all the efforts, all the years of efforts, in almost 7 years, did they produce a single investor or a single lender with cash? The answer is no, by their own admission. This project was never de-risked. It was plagued throughout by shortfalls in capital. People who looked at the project saw in the partners' own financial statements a dearth of income, escalating deficits, and a clear path to insolvency. And at the end, EuroGas, with 90% of Rossman's shares, had suffered an enormous judgment, had gone into bankruptcy. So, in a project that was estimated to require 30 million euros, according to their own expert, they had invested in working capital, according to their own expert, less than 2,500,000 euros, which ends up being about 6%. Now, before I turn the floor to Mr. Pekar, which I will do momentarily, claimants have made repeated references to allegations of corruption. At the end of the day, respectfully, there is no credible evidence to support those allegations. And given the utter lack of the evidence, we're not going to comment further. But we do note that these kinds of allegations have regrettably become a common tactical maneuver. Or in the words of Mr. Garavi, candidly noted at page 102, line 2 of his opening statement, we don't want to establish corrupt practices, it's just for the ambiance. The fact is that following the Supreme Court's decisions in these cases, the process implemented by the respondent fully complied with all measures of due process. We do urge the panel to read the decisions and look at what the DMO did afterwards. Having followed the process and having taken an impartial decision in the public interest to put this deposit into production after no real progress had been made in 7 years, the respondent reached a conclusion which the claimant did not like. It is precisely for this reason that we've heard allegations of impropriety and corruption for ambiance. Corruption is a convenient word to use when a decision has not gone in your favor. Thank you, members of the tribunal.
Good afternoon. Members of the tribunal, this late afternoon, knowing that I am the only thing which keeps you awake from well-deserved dinner, I will try to be a bit quicker than my slides and not retain you here too long. But they are.
Thank you. Some microphones should be closed. Thank you.
There are 5 topics that I would like to discuss this afternoon. First is definition of dobivanie. Second, the point that I was making at the cross-examination of Mr. Zložník, which is that Rozmin did not and was not authorized to conduct mining activities, not dobivanie, but mining activities, which is banská činnosť in Slovak, and I will explain what it is, at any time in 2002 and 2004. Then the fact that delays in the permitting proceedings between 2002 and 2004 were caused by Rozmin's defective applications. Then I will spend a little bit of time with some quotes from the second Supreme Court decision that Mr. Garabi interprets in an original way. And then the last point, I will briefly address this absolutely new claim that somehow BSK Mining was not able to open the mine within the statutory deadline. I appreciate that you have heard a lot about dobivanie, and I appreciate that it must be terribly difficult for all of you, including Mr. Garabi, who do not speak Slovak. The cause of the problem is this, and it's not too difficult. In Slovak, there are mainly 2 terms, dobivanie and banská činnosť. The difficulty is that when those terms are translated into English, the translators would very often use interchangeably mining, extraction, excavation for dobivanie, and they would also use mining for banská činnosť, which means that we then have in English an overlap with respect to mining which does not exist in Slovak. And the best illustration of it is, you may remember there was one document we had with Mr. Rozložník that was the plan that they submitted in I believe, 98. It was claimant's translation of this document. The name of the document stated plan for opening, preparation, and mining. And then when we went into the table of contents, we saw that it was speaking about opening, preparation, and excavation. So this was a blatant example of how the mining, and in the Slovak version, obviously the third word was always dobivanie, both in the heading and then in the table of content. So this is just an illustration of the difficulty. So I do appreciate that it's really difficult for you, but I will try to show you that this is not difficult for those who speak Slovak. So we all know that the critical term for this arbitration is dobivanie, because this is what was required under the 2002 amendment. There was one issue which didn't make it into Mr. Garabi's closing statement, which is that in the statement of claim or memorial, we read a lot about how Rozmin was taken by surprise by the application of the 2002 amendment, that they didn't know, and so on. So that's why I clarified at the cross-examination of Mr. Rozložník that he was well aware of the 2002 amendment. And here is what he confirmed. I asked him, was it your understanding at the time, back in 2001, 2002, that if Rozmin does not start dobivanie within 3 years, it will lose the license? And his answer was, yes, certainly I did realize that as an executive back then, and I have reminded the shareholders of this fact. This is really interesting, because if Dr. Rozložník did not understand what dobivanie means, as he now may be claiming, especially when answering to Mr. Garabi's questions, what is it he conveyed to his shareholders? Are we told here seriously that he told them there's a new amendment and I don't know what it means? We also are in agreement that the statutory definition of the term dobivanie was introduced in 2007, which is too late from the perspective of our time period, so we do not need to look at it for the purposes of interpreting the provision back in 2005. But it is still important, actually, because I submitted to you that this is the definition that everybody in Slovakia understood it to be even before 2007. That term was generally known and absolutely clearly understood even before 2007. And Mr. Kukalczyk explained that this is mainly because of this decree from 1989. We heard that the decree does not provide a definition, but this is correct. But please do look at the terms of the treaty. You have it on the screen right now. It says section 2, my apologies. I first have the Mining Act, which is important as well because that will clarify the confusion between what I would call mining activity, in Slovak banská činnosť, and what I would call excavation, but we can also call it extraction, doesn't matter so much, which is how I understand dobývanie. What you can see here is that the Mining Act defines mining activities, and there's lots of them. And the dobývanie, which is here translated as excavation, it's in the middle of the highlighted line, is just one of them. So this allows us at the very least to establish that mining activity is a much broader term than dobývanie. And this is why it's so incorrect and confusing when the translators, in good faith, I appreciate that, would translate dobývanie as mining, because then this creates this confusion that we do not know if we speak of something very specific or, contrary, a very general term. And this is very general term, banská činnosť, is then, you can also see it in the permits that Rozmin had. So, for example, we have the general mining permit, which again is oprávnenie, banské oprávnenie. This is the general license, sort of like my trolley license I have in the Czech Republic, which authorizes Rozmin to conduct mining activities. Or we also then have it in the third, the most specific permit in a way, which is the authorization of mining activities. Again, it uses mining activities in Slovak banské činnosti because what is permitted is obviously not only excavation, dobývanie, but also the opening of the deposit and the preparation of the deposit. And we saw it in the plans. The plans specifically referred to opening, preparation, and dobývanie as the third stage of the process. And this general relation between banská činnosť or mining activity and dobývanie was confirmed by Mr. Rozložník, who obviously agreed with me that opening, preparation, and dobývanie are all mining activities and three different activities. Now let's go to the decree from 1989. The one interesting thing that we have from this decree is that the decree says that dobývacie práce, which means like dobý works, excavation works, can only be commenced after the completion of necessary opening and preparatory works. This is something which is familiar to you because all the plans you saw had precisely this sequence: opening, preparation, dobývanie. We do not have the full document in the record, but the document then also lists the so-called excavation methods, and that's what you had then under the heading dobývanie, because in Slovakia you cannot mine material just in any way you like. That has to be a method which has been pre-approved and which is put into this decree. But maybe I'm getting too technical now. Third, there was also in technical literature, it was absolutely clear that what dobývanie means. We can skip that. And now we come to the, in my view, most important point, which is that we know that Rozmin submitted two plans in '98 and in 2004. They were both signed by Mr. Rozložník. And in those reports, written in the Slovak language, he had a section on dobývanie. And this section on dobývanie corresponds, by its substance, exactly to the definition which was later put into the law in 2007 and which was commonly understood by everybody in the mining industry to mean dobivanie. So Mr. Loznik knew what it meant. And then another very important point is that those plans were formally approved by the mining office. So one can obviously assume that if something was wrong with those plans, for example, if the usage of terminology was incorrect, the mining office would have reacted. No, the mining office confirmed them, because why wouldn't they confirm something a document which uses the term dobivanie exactly for what dobivanie is? And here you remember those documents when I went through them with Mr. Rozložník, so here is just a few more quotes. The first slides relates to the 98 plan of opening preparation and dobivanie, and then the following slide refers to the one submitted in 2004. I invite you to review them again, judging them by their content. There is no doubt whatsoever that Mr. Loznik understood what dobivanie is, and that was the basis for the permits that he was able to obtain. And then it's quite interesting, because when I asked him the question, and I asked him what dobivanie is, he gave me the definition. He gave me the right definition. He said that dobivanie is the exploitation of a selected mineral according to a predefined method, and so on and so on. Exactly what we say it is. Then when Mr. Garabi was asking him his questions, he changed his testimony, and suddenly it was something completely different. You may recall also that we had some issues with the Slovak version of Mr. Rozložník's written witness statement needing significant improvements, which he was candid enough to make before the tribunal. Then we can move to point B in the interest of time. And the point B is that even if we do not take this correct definition of dobivanie, and instead we somehow accept the position which was mentioned by Ms. Bergman today, that somehow mining works would have been enough to save the excavation area. Well, the reality is that Rozmin was not even conducting mining works in 2004. And why is it? Well, here I have to go back to the original permits from 2000, let's say, and that period. We know that there are now 3 stages of starting the extraction of mineral from a deposit. First, opening, preparation works, excavation. And then there is something which has to take place at the same time, and this is surface construction activities. Because obviously the mine cannot exist without surface constructions just like that in the middle of a forest. So they needed to build accommodation, infrastructure facilities for the workers, and so on. And that is not included in mining activities, so they needed a special building permit to do that. Then they needed to build some special buildings, bridges, and water management structures. Water management structures proved to be very important and very problematic for Rozmin. The water management structures, so Rozmin first got the permit from the mining authority, but only for the mining activities. And it then also obtained all construction permits for surface construction from different authorities, environmental office and building office. And we touched that with Mr. Rozložník, who confirmed that this is so because this is not related to mining activity. The permit was issued by water treatment, water management companies. They should have said authorities, but it doesn't matter how much. That is where we had to have deadlines extended, not with the mining office, because it was not mining related. Which also means that when Rosmin decided to formally inform the mining office at the end of 2001 that they were suspending mining activities, this per se did not affect the permits they had for those surface structures, because they were governed by different permits. And those permits were still in force because Rosmin was periodically applying for their renewal, and Rosmin obtained their renewal. So here on the slide you can see that actually they could build the whole time in 2002 for even until May 2005. And now why the water management structures were so important. We were discussing with Mr. Rozložník the physical location of the deposit, and it's close to a creek. And the creek is in level 3 protection of sources of drinkable water. Mr. Rozložník actually thinks that it should be level 2 protection, more severe, but it doesn't matter. The problem is that if there is some contamination of water coming from the mine, that would compromise sources of drinkable water for large part of the population in the area. Therefore, it was absolutely essential to make sure that there are proper water management facilities put in place. At the beginning, both Rosmin and the mining authorities and the environmental authorities were optimistic and thought that this will be what is called a dry mine, meaning that when they dig into the rock, into the mountain, they will not encounter a spring which would start flooding the mine. If it happens, it's not a problem. Actually, most mines do have it this way, but then it means that there have to be pumps available so that the water is taken out of the mine, and it has to go, logically, to the creek. The way it can be addressed is there is a water management plan which treats the water, and that's fine. So at the very beginning, they thought there would be a dry mine, and that's why they were authorized to do both the drilling into the mountain and the construction of the water management facilities at the same time. What happened, though, was that this assumption proved incorrect. When mining, they went into a water source, and the water source started to flood the mine. So that happened. What then happened when the construction was suspended is that the entire mine, the 93 meters that they were able to excavate, were completely flooded with water. The water management authorities looked at it and said, okay, because you have water coming in, we can no longer allow you to do the water management plant and the actual drilling at the same time. But you have to have all water management structures in place before you can start mining activity again. And the reason is, and then there are two subsets of that. The first subset is the drilling of the water which was already there. This is relatively simple and, may I say, clean process, because what happens is that you just have a pump and hose and you take the water out of the mine. It needs to be treated, but the treatment does not need to be so thorough, I would say, because in principle the water is not contaminated itself. The problem is that when the big machines, and I believe that you can imagine how big the machines must be in order to be able to dig a 4 meter times 4 meter profile into the rock, start digging. And then there is the water coming somewhere from within the mine. The water first goes down, obviously. It goes by those machines. Then at the bottom of the mine, as it is being drilled, it is pumped out. But this water is heavily contaminated by oil and especially lubricants coming from those heavy machines which are used. So the level of treatment of that water must be much higher, much more thorough than the one needed just to pump out the water which is already there and which I heard is even drinkable in principle. So this is why in 2002 the environmental authority said, okay, if you want to resume mining activities at some point in the future, you have to build the water treatment facility first. So when then Rosmin in 2004 reapplied and obtained actually the authorization of mining activities, the authorization made absolutely clear that by this decision are not affected rights and duties according to special regulations comprised in decisions and statements of other authorities of the state administration. This is a pretty convoluted way to say that you must observe the water permits that were given to you by our friends from the district environmental office. And this is something which was also expressly acknowledged in the minutes of the 8 December 2004 inspection. Because if you look at this third paragraph from the bottom, it says, Rosmin has performed, and still performs, works related to the completion of surface water management construction due to the limitation of performance of mining activity by decision of Rožňava District Authority, which is conditional on putting temporary surface building into use. So this is absolutely critical because it shows that until those structures, all of them, were put into use, not just put into use in the sense that they started to use them, but if we went, well, let's not go back, but the decision of the environmental authority actually refers to commissioning. And commissioning under Slovak law means two things. Basically, there has to be an inspection of the structure when it's built. The person comes in, looks if it works, and then there's a special protocol which defines how it will work and what parameters of quality of water will have to be complied with before the water can be put into this creek. So it's, again, a formal administrative process. And this formal administrative process never happened. The only one structure, water management structure, which was put into use is the one called water management plant. It was put into temporary use just for the purposes of cleaning the water which was already in the mine. But it was not the full set of water management structures which needed to be put into full operation before Rosmin could resume mining activity. There's one very troubling aspect of all this, which is that Rosmin had known since 2002 that they had this obligation, or rather that they had this impediment to even resume mining activities. And the cost to basically build those water management structures was not exorbitant. Sigarit actually was proposing to do it for approximately 4.5 million Slovak crowns, which, if my math is correct, is like 160,000 euros. So a relatively small amount that could have been spent, frankly, back in 2002, back in 2003, at the beginning of 2004, at any time, because they always had the permits to do that. They didn't have to wait for anything, but they decided not to. They didn't have the money, they didn't really want to do that, we do not know, but what we do know is that they never did it. Here on the next slide you have the list of all the structures, water management structures, which had to be put into operation, and we know that the only one which was actually put into operation is the last one. And this is, the following slide illustrates how this permit, which we would want to see for all 8 of those structures, looks like. First, there's the right to use the permit, a temporary utilization of a portion of the water works implemented as part of the project, and then it specifically refers to this construction object 24 mining wastewater treatment plant. And on the following slide you have evidence of what I said, that it was approved only to clean the existing water. And so Rosmin, this is why we have to say that until the very end of 2004, Rosmin did not have the right to engage in any mining activities. Because they did have the big permit, so to say, but the big permit was expressly conditioned, or rather did not trump or did not prevail over the smaller but just as important water management permit, and which expressly prohibited them from resuming mining activities before having all those buildings commissioned. And they didn't have them commissioned. And then, as a matter of fact, actually, we were also discussing with Mr. Loznik what it is that Siderit was doing at the site at the time, at the end of 2004. We went through the construction diary. We saw that all they were doing was to build those surface structures, some of them, and Mr. Loznik admitted that building of surface structures is not mining activity, which is actually quite logical, because I assume that Rosmin would not dare to do mining activity before, in violation of the terms of the water permit that they have. So now quickly to point C, I believe that this is very well written in our reply, our rejoinder. So I would only point you to some key facts. First of all, we were discussing quite extensively the differences in design of the winds, or the overall, let's say, mining plan, which was submitted in '98 and 2003, and we discovered at the very end that there was virtually no difference. It was only these winds, and even though Mr. Loznik was very much convinced that they should also do the edit, he also confirmed expressly when I asked him that the permit they asked for and got in 2004 was not a permit to build the edit, just the winds. That obviously begs the question, how come that it took them so long to simply reapply for something that they had already approved? Another big question is, how come that it's being claimed that they didn't know what documents they needed to obtain this approval? Oh, they went through this approval process already in '98, so it was the same documents from the same sources. So this is why we conclude that they were fully aware of everything they needed to submit. And then when I asked Mr. Loznik about whether he did know what documents he needed to submit, he, says, so you had no doubt with respect to what you needed to supplement or not? Yes, that was very clear. He knew what he needed to provide. Then, point D, I would, members of the tribunal, invite you to read the decision of the Supreme Court, both the first and what we call the first and the second decision of the Supreme Court. I do not suggest that you try to find there any inspiration with respect to the writing style, but the content is interesting, and actually it is not what Mr. Garabi says it is. So first, the first Supreme Court decision, basically, just to remind you of the procedural history, there was a first decision, or even not formal decision of the District Mining Office notifying Rosmin that their rights were forfeited. They appealed that, or brought the issue before the regional administrative court. They were not successful there. They went to the Supreme Court, and the Supreme Court said, yes, you are right. On procedural grounds. The court said, yeah, your right to be heard was not respected because there was no formal administrative procedure. So I found it very cheap, I must say, when I sat here on day 3 and heard the questions asked from Mr. Kukalchik, all the questions about whether due process was observed or was not observed, and those questions were always carefully framed to only refer to the period end of 2004 and 2005, carefully to be sure that he cannot speak of the decisions which were then later issued after the first and second decision of the Supreme Court, but only about this first decision, which we all know was not procedurally correct. I mean, this is a res judicata under Slovak law. The decision was quashed. The decision doesn't exist. In terms of public international law, investor sought redress domestically and was fully successful. The decision was quashed. One important thing is the Supreme Court never said that the DMO or the MMO or anybody else was supposed to specifically warn Rosmin that something might happen. This is not how those laws worked. if I were to oversimplify it a little bit, I have here my passport which will expire in 2 years. I will not get any notice from any state authority that I need to renew it. But one important thing, when Mr. Kukalchik was asked about that, he specifically referred to a very informal meeting that he had with Mr. Rozložny in September 2004, and when he discussed it. So it's not even factually correct for claimants to say that absolutely no notice was given. It's in the transcript, day 3, page 167, line 17. And then we have the Supreme Court, the second Supreme Court decision. So what happened in between is that the District Mining Office issued a new decision in a formal proceeding in which it heard Rosmin. Rosmin appealed that to the main mining office, not successfully, then to the regional court, again not successful, and it went up the chain to the Supreme Court again. So we are now in 2011, 2012. Please do read the decision, but the main points of the decision are: the court said the decisive date is January 1st, 2005. That's at the very bottom of the first line. And the court criticized. We heard about decision being premature and so on. Well, yes, this is because the court understood the very point that Mr. Garabi was making, that if the district office was sending a public announcement of the tender to the official gazette of the Slovak Republic on December 30, then it logically must have in its mind made the decision before. The Supreme Court understood it and clarified that. Yes, it was premature because the decisive date is January 1. The difference is 2 days. In Slovakia, they are not very much in favor of the doctrine of non-substantial error. So when they see an error, they correct. So here, 2 days wrong, but still 2 days. Then the main thrust of the decision of the Supreme Court is that more factual findings were necessary. For example, the Supreme Court had one thing which does not really comport with what claimants are saying about the decision. The Supreme Court expressly said that the minutes, and the minutes, it means the minutes from the inspection on December 8, 2004, do not indicate whether the plaintiff did or did not start to perform works immediately leading to excavation of the deposit itself. There's no photo documentation. Then they say the fact that the plaintiff did not start mining the fault is clear from annual reports on mining activity from up to 2003, 2004 is not included in the file. One important thing is that the court did consider this information to be important, but the court missed the information about mining of talc in 2004 in the file. We now obviously know that no talc was mined in 2004, but the information was missing. And that was a problem from the perspective of the Supreme Court. Another problem from the perspective of the Supreme Court was the lack of the lack of explanation for the decision for the definition of dobivanie that the district mining office adopted. And again here, the court doesn't say that it was a wrong definition or the right definition. The court only says that it was wrong to use that definition without an appropriate reason. So the definition was not explained well enough. A procedural issue, not a substantive issue with respect to the content of the definition. And then the court also said that the district mining office should have made some proportionality analysis, that there should have been an assessment of public interest. And the court went on to propose how the assessment of public interest might go. And one important thing is that the court expressly said that it's absolutely okay to reassign the area if the company that has it behaves speculatively. This is the last word in the first extract on this page. The Supreme Court also said that if an organization with assigned excavation area artificially delays the start of excavation of the deposit, then it is clearly more effective to reassign. Artificial delays. And so members of the tribunal, if you do not believe Slovak authorities, now you know enough about the behavior of Rosmin, the behavior of claimants. And you can ask yourself whether their conduct was speculative and whether the delays were artificial or not. So, what is it that the Supreme Court did? The Supreme Court basically said there are many factual elements which are missing, and that's why we remand the case back to the District Mining Office to make a new factual assessment. What happened is that the District Mining Office did that. They produced a 66-page long decision, which is in the record. We have not heard a single question about that decision from Mr. Garabi. Why? Because the decision is difficult to be attacked. We submit that this is also why the decision was, unlike the first two, was not put under judicial review in Slovakia. Claimants knew that they had no chance to win this time. And very last word on this brand new claim that somehow the VSK mining was not able to open the depot or start excavation within the statutory time period. This is a new allegation, that's why we were not able to react to it in our written submissions, and therefore we also didn't have a chance to submit written evidence which would prove what I'm going to tell you right now. So first we have heard from Mr. Chori yesterday his testimony that the first ton of talc was extracted in April 2009, which is when they finished opening works. You now know how it goes: opening, preparation, excavation, dobivanie. So obviously when they finish opening, they have to reach the deposit, so they have to take something from the deposit. So that's what happened in April 2009. And then in March 2010, they started the actual excavation, and there's documentary evidence for it, rubber stamp, with a stamp by the District Mining Office. And if you count, they were assigned the mine or the excavation area to construct the mine in April or May 2005. So they did make it within the 5-year period, which is the period which applied to them after the amendment in 2007. I think that's controversial between the parties. Thank you, Mr. Chairman. This is all I had on the small declarations.
Mr. Chairman, I will conclude the Slovak Republic's remarks. And
Sorry. About these decisions of the Court of Cassation, we know well the decision of 2008 and the one of 2011. The third one is mentioned. It exists, but I confess that it's less clear in my mind when it was rendered and what it says. That's Mr. Becker.
Yeah, thank you. To be absolutely honest with you, I believe that the decision is not relevant because it relates to the revocation of Rosmin's general mining license and not the excavation area. So it has nothing to do with the events of 2005. Thank you.
So, Mr.
First, members of the tribunal, would just like to thank you for the time and attention you've paid to the case over the course of the last week and in fact the last 2 years. I want to close with 2 final remarks, one procedural in nature and the other simply thanking some particular people on our team. The procedural issue is I just had an opportunity to speak to Ms. Holikova, who, as you know, heads the Slovak Ministry of Finance Investment Treaty Arbitration Team. And although we had originally asked for post-hearing briefs in view of how the hearing has gone, we no longer feel that's necessary. Now, of course, if the tribunal wishes us to file them, we certainly will do so. And we can, of course, talk after our presentation about that, but I did want to state on the record what the Slovak Republic's position is. And then second, finally, I just wanted to, again, conclude with a few thank yous. And specifically to Ms. Holikova and her outstanding team at the Slovak Ministry of Finance. I think it's appropriate at the outset, well, really at the end of this hearing, to emphasize how instrumental she and her team have been throughout this case. They work every bit as hard as we do, in fact, probably a little bit harder sometimes, and it really does make a difference. Just one example of that critical contribution from her and her team. One of the ministry's lawyers, Mr. Radovan Hransky. Radovan, can you raise your hand? I told you that we found out about EuroGas 1 and EuroGas 2 by researching the public record. It was Radovan that actually found that out. And as we now end, perhaps we end where we began, with that misrepresentation that is at the very heart of the case. And we might ask ourselves, if it weren't for Mr. Horonsky discovering that, where would we be today?
Jurisdiction. Again.
With that, Mr. Chairman, I close the Slovak Republic's closing statement.
Thank you. So we may have other questions. And while we discuss that, maybe a quarter of an hour, or maybe less, let's say, at least 10 minutes at least. You might discuss between yourselves a few points that come after we have closed this hearing. Post-hearing briefs, you express your opinion. Statement of costs, when and in what form. Revision of the transcript, when. And transparency, when, how that will take place. Do you have requests, or will you have requests for deletion of some parts of the transcript and the video? So you can already start discussing that maybe while we are in our room. So at least 10 minutes you can just do what you want. So we have a few questions. Professor Gerhard.
Thank you, Mr. President. It's a question primarily for respondent. But of course, if claimant has a comment there, it's welcome as well. It has to do with the last slide, Mr. Pekan, of your presentation, where you discuss the issue of when in fact with the new owner, the Dobby Vanier actually took place, because in the record so far, and you correct me, I'm just stating something, but if it's not correct, you absolutely correct me. What we have is the testimony of Mr. Courage, which answered a question which I asked him about that. When is it that with the new ownership, Dobby Vanier took place, and he starts. It's in tab 80 of claimant's excerpts. He starts to say that mining and excavation, TASBA and Dobby Vanier are pretty much the same thing, or can be used interchangeably. And then against that background, he says that he thinks that, I quote, "I think that the key deadline was April 2009. This is when the first ton of mineral was excavated." So it seems it's unclear to me if it's a deduction. The deadline was that, therefore it must be before, or if it's an actual fact, because he also qualified his statement by saying that he was not in charge at the time, he was only an engineer. So, and that's why it's a question I'm asking to the respondent. In actual facts, when is it that Dobby Vanier took place under the new ownership? Because I suppose, or I guess it's a twofold question, and I put all the questions at the same time, so it's not a cross-examination. It's does that important event give rise to something in writing, minutes or something? Question one. And question two, if in any event, irrespective of the answer to the first question, when did that happen in actual fact? Because I see that you deduce it also in the last bullet point from another event. So is there an actual fact, and what's the position of the Republic on this?
Thank you, Professor Gaillard. The actual Dobby Vanier started, as I stated, in April 2010. And we do have a document which, however, is not in the record. because, and I was trying to explain that this is because this claim was presented only at the hearing when we do no longer have the ability to submit documents, but we actually do the document even here on our
So
computers.
the answer to my first question, does this important Dobivanie days give rise to minutes? The answer is yes.
Yes.
Right. And the document you're talking about are the minutes of this event, right? Or
No, not only of that event, it's a longer document which has it discusses several issues, but there is one paragraph of the document which says that on that date, I don't recall the date, let's say April 10 of 2010, there was an inspection from the district mining office, and the inspection witnessed the beginning of Dobivanie. They state, I think, the number of tons, which again I don't remember, and they specifically mentioned the method, the excavation method used, and they state that it's in accordance with what has been approved for excavation.
Right. And how do you explain the press article which is used on the other side, which seems to talk about this event in the future? I mean, we heard Mr. Courage, I believe, as well saying, well, the press is saying anything, but in fact the press was quoting the former management. So what's the position of the Republican?
It is.
I mean, the new management.
Yes. It is my understanding, and this was not our main focus, obviously, but it is my understanding that the levels of Dobivanie, or levels of ťažba, I should say, production, extraction, were relatively low, and still are.
Right, so that may explain that the new management is saying we still do not extract
Well, I can tell you a little bit more because I had the privilege of seeing the mine, actually. So I was actually in the mine. So as I said, the production levels are relatively low, and we were explained by the management that they needed to further de-risk the deposit from within the deposit. So as they were basically preparing the deposit and progressing with their Dobivanie already, they are still making some additional boreholes to know exactly how the deposit looks like and so on. So.
Okay. Thank you for your explanation. I guess it's less relevant for the respondent because, right? Maybe a question, a related question. Why is it that you did? We heard your expert saying I couldn't go to the mine, or I didn't go to the mine. Was it denied access, or you didn't just you didn't ask it? I mean, your side. I don't mean you as an individual, but the claimant's side.
It's difficult for me to respond on the spot. Our understanding from the record is that there was no proof of extraction, and we put the question to correction. We obtained this answer, and here it is. And we believe still on the record, on behalf of respondent, there is no proof of extraction. We have left with the article. They're talking about a document in their position that dates from April 2010. Why they have not put it on the record? Why didn't they ask for it to be put on the record? They don't know the date. How come they do not know the date? Is it also a form or substance? We know that they have their introductions in the government. We know that it could be a rubber stamp, just to say, okay, we extract something, but in practice, and that's what we just heard. It's not an ongoing process. It's a one-spot shot to get away with paper and to use it to be in compliance and then to be able to respond to us.
Thank you anyway, and you both answered my questions, Mr. Prakash and Mr. Garabi. Thank you very much.
Yeah, Professor Gaya, I would just say that I didn't think that it was so important, but the date of the document is April 9, so I was wrong by one day. It was a formal letter which was written by the owners to the district mining office and telling them formally that they have started Dobivanie. And I repeat, the reason why we didn't put it into the record is that this issue had not been raised in claimant's file written submissions. But we are absolutely fine putting it into record now if the tribunal would find it helpful.
That's a decision the
And-
tribunal will have to make. But did you answer my question?
Is it requested by claimants to see the document that has been described?
Well, what we are describing to us, for us, it's a unilateral letter. Was it sent? Was it received? What are the following correspondence? And what is the exact status of the project today? So if we're going to go into that, then we have to go all the way and do it properly. For us, it has not been established on the other side. We have the key witness here who didn't know, and there is an article out there that reports a key person's representation that there is no extraction, talks about it. But if the tribunal wishes to go in there, we want to go all the way and not just bits and pieces, and not on seal form. But we're going to find out what happened.
As far as I'm concerned, my questions have been answered. Thank you.
I have 3 questions for claimants. First question, in your reply, you request the tribunal to order respondent to pay claimants damages, costs, etc., in an amount to be quantified at a later stage, etc. Of course, we have not gone to the quantum stage. It's possible that we do, possible that we don't. It depends on what we decide on jurisdiction and liability. But apart from that, even not knowing a quantum, there's certainly a proportion, whichever the number we would find on the quantum issue, it would have to be divided, because we're not going to grant damages collectively, even if we are to grant damages. So, what's the proportion?
What's the proportion? The proportion is in proportion with the percentages of the shareholding of each company.
So which would be 57, but it's not.
Yeah.
It's not over 100, but it's
Yes.
33 or 4.
57% us, that's what we did.
57.
Yes.
And
30.
33.
33.
But we've quantified that the claims, and usually it's John Anderson quantifies it according to the number of shares. That's how he usually does, and I recall I saw something of that.
Okay, no, it's good to know officially by you. I go for it. Second question. You remember this document R158, which is a Belmont's news release of 20 November 2013. It tells the press what the agreement between Belmont and EuroGas is,
Yes.
and it says the company, that's Belmont, has agreed to provide a power of attorney to a law firm located in Paris, France, which is acting on behalf of both Belmont and EuroGas Inc. in filing an action for damages against the Slovak Federal Republic, etc. The agreement with EuroGas also stipulates that Belmont will not be responsible for any expenses, legal fees, or disbursement with respect to the lawsuit, and that the company would be entitled to receive from EuroGas 3.5% of any award or settlement from the lawsuit. And that surprises us,
Yeah.
and would like I mean, it's good that we offer you an opportunity to explain.
Yes, but, President Mayer, first on the theme of being naked, we have submitted in document production a agreement even between Belmont and EuroGas, clearly stipulating the allocation of the potential proceeds of an award. So, and we've submitted that to respondent who has chosen not to produce it on the record, nor question the council on this issue. Second, the
So
agreement.
no one has produced it?
No one has
Submitted.
produced it, yes.
Submitted.
Respondent has asked for, it falls within the scope of your document production order. We have complied with it. We have submitted to respondent. Respondent has not submitted it and has not asked any of the parties to this agreement who were present any question on this. I just wanted to give you that background. There is that press release and, more importantly, an underlying agreement that has been entered. The agreement is, if you read it, good luck in understanding it, because it is very complex formula of 3.5%, and it's not even sure, if you read it, you would understand that 3.5% EuroGas having to pay Belmont from EuroGas's shares or the contrary. So the press article is misleading, I would say. Also, there is a cash amount provided. Against this background, my understanding is that there were certain exchanges between Mr. Robal and Mr. Aigagos on this subject, where Mr. Aigagos thought that they would not be full financing from a third party funder. Once Mr. Aigagos found out there is third party financing and found out more about the arbitration process, there is, to the best of my knowledge, and I regret that the two gentlemen on the stand were not questioned by the tribunal or a respondents council, who has even done the 9 agreement on this subject. That's all I can tell you. I can add also is that there is no consequence either way, even if it's Belmont that gets 3% from the shares of EuroGas's proceeds, because this is just the allocation of, it's like if I get 90% success fee on a case. I know it's an element for you to consider that you may think is very relevant or material, but legally speaking, strictly speaking, it has no consequence on the question you're asked to settle. Okay.
Would any party wish to submit that document?
Again, we are transparent. If the tribunal wants it, it can submit it. If respondent has it in its possession for a long time, it has not produced it. If it wants to produce it, then it has to make the motion. If you
Mr. Chairman, I confess, the document production was so long ago, I truly don't recall whether it, I mean, I trust my colleague when he says it was produced. I am not able to recall that. I'd have to go back and check and respectfully request an opportunity to review the document before responding to that. Although, as I understand, there's no objection from claimants if the tribunal wishes to see it produced in the record.
Of course not. Of course
The
not.
tribunal, the tribunal wishes to see it.
Okay, with the understanding, then there may be other documents now, and that agreement does no longer stand. Because there is a subsequent agreement of third-party financing with respect to Belmont and La Française and EuroGas, where there is no such allocation of any shares. Each party keeps the 57%. So if you want to go down that route, we were very happy. Respondent didn't want to go down that route, but it may entail just more than 1 or 2 documents.
maybe we have a very short break of 5
Up to
minutes
you.
to discuss
Up to you.
between ourselves what we want
Yes.
and what we do not want. Now that was the second question, and the third one, so again to that's to Mr. Garavi. What is the date, or what are the dates of the breaches of international law that you are complaining about? And I'm not, first, that's not related to the issue of when did the dispute arise. Not that. And I'm not asking you to make a choice, not at all, because there may be several breaches
Yes.
or a continuous breach, but can you clarify that?
For us, it's the date of the revocation, January 3rd, 2005, of our rights. And then there are subsequent breaches, I would say. We do not read the decisions of the District Mining Authority when its decision is quashed and sent back to it, that just rubber stamps it. We think that's an independent breach afterwards. Independent meaning within the context of the same global breach. And then again, when it goes to the Supreme Court, when it comes back, and spends 100 pages, a lot of resources to use whatever it can to, again, create cosmetics and allow respondents' counsel to say, oh, it's so important, and the other side didn't address it, that's why they gave up. That's for us another breach. It has nothing to do also with denial of justice.
Thank you. So we're going just outside to discuss what documents we would like to receive.
Also, we can offer the main signatories of this, there was a missed opportunity to hear directly what they have to say on this issue, instead of me having to say, oh, they found out about financing. This, Mr. Agego is not an arbitration professional, so that's an offer for you as well.
So we would like to receive two sets of documents. The first set, Madame Cleya will explain.
Well, the first set would be the document you offered to file, which is of 9 April.
Yeah, this is actually two documents in one. One is dated 9 April. This is when they informed the authority that they had started. And then there's the minutes from an inspection on site, which is April 14, so 5 days later. So we will provide both of them.
We would like these two documents plus any other subsequent documents related to the same topic.
Okay, we will have to ask the general then for the subscribers.
So that's one category of documents.
And the other one is all the successive documents which you mentioned, Mr. Garavi, on the percentage sharing between the two parties of any proceeds from the award. Yes, the agreement which was incorrectly described in the press
Yes.
release, plus
Yeah.
any. So, to whom do we ask that?
Well, we just
maybe-
saw you have it. We have the confirmation that we send it with the documentation. So if you want to produce it, you will be happy to produce it if you want to produce it.
The version we have does not have the attachments to it. The document itself, it just noted references to attachments, which are not missing. But we're happy to send the document you provided us to the tribunal, although it probably would just be more efficient if you send everything since your documents. It's up to you.
Again, what we have, we sent. So the other agreement is subsequent dates from March 2014. It is a little bit more complicated. I don't know if there is a third one, but the second one is with third-party funding. So that has contains some privileged information in terms of strategy, amounts reserved for this, amount of a prospective settlement. So we will submit it to you with the paragraphs redacted.
That's
All right.
agreeable.
Okay. And I'll see what else is there.
Thank you. Now, the issues which I mentioned before we broke, haven't got to an agreement or an agreement on when we will have an agreement.
I think we have agreement on everything.
Good.
You haven't said?
No, we have not settled, we'll not have agreement on that. So, Mr. Garabi will correct me if I misstate anything, but parties have agreed not to submit post-hearing briefs, unless of course the tribunal requests them. We have agreed to submit our costs within 30 days, correction to the transcript 30 days. With respect to the form of costs, each party will simply provide the lump sum amount. If there are further questions about that amount, the other side can of course raise it at that time. And then with respect to the videotape, for which we thank Lindsay, you in particular, and also our cameraman, we both have agreed we don't have any confidential information that will need redaction. I think the only thing we agreed we would take on is when I got the Utah law question from Professor Garabi wrong. So with that, I think it can be published as soon as it's ready. We would request, I haven't discussed this with our colleagues on the other side, but I think maybe if you could delete the breaks, just because people are walking around the rooms and there are microphones.
Yes, we'll do our best to edit it in a
Yeah.
simple form.
Yeah.
But am I to understand that we can, I will obviously give heads up if it's going online. It'll take some time to do that editing. Are you fine if we don't submit it to the parties first and just put it online, or would you like to have a look first?
Speaking for just our side, I wouldn't mind having a little bit of advanced preview of it, but I don't know if you have a preference. We're certainly not going to watch a week's worth of hearings, but we may take a glance at it.
Somebody is.
Yeah.
So I think this brings us to the end of this hearing, and we thank the parties, the council, for their very clear explanations, with a special thanks to the lawyers from Utah, because we are not familiar with these issues of bankruptcy law, and you were extremely clear on them, although it seems to be extremely complicated.
I don't think it's as complicated as your world, but it was a pleasure to be here. Thank you very much.
Our world is rather, it's more obscure than complicated. We also thank, of course, the cameraman and the court reporter, and although they're not here, the interpreters. Also, thank you very much.